Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. If you've ever had a question about your employment law rights, then you've come to the right place. Welcome to Ask a Lawyer. I'm your host, Dana Levinson. Each week, we dive into different employment-related topics that are on many Canadians' minds. I'd like to welcome my guest for today, Lior Samfiru, partner at Samfiru Tamarkin LLP. Before we get to your emails and phone calls, Lior, tell us why it's important that everyone should know their employment rights.
Well, Dana, it's obviously a big part of our lives. Work is, and you know, there's even been court decisions that acknowledge the fact that work plays such a fundamental role in our identity, in our well-being, and without employment law, we don't have any rights. And in this province, I've said this before, we have some tremendous rights, but so many people have no idea what their rights are. And there's a lot of misconceptions there. You may go on Google looking up some of your rights, and you will find, I can almost guarantee you, wrong, incorrect, or incomplete information. Well, on this show, as always, we talk about the things you need to know, the rights you didn't even know you had. And by doing that, we'll have better, more informed employees and employers. And that's good for everyone.
So from the calls and emails that you've been getting over the past week, what issues really stand out for you?
So a call that I got this week, again, someone that watched our show, very important, and I think it's an issue that a lot of employees and employers struggle with. So this particular person had an attendance issue one week. She was late to work, and not a good thing, of course. Her employer gave her a warning, said you're expected to come into work on time. Fast forward about a week and a half later, she's again late. She's called into a meeting. Employer said, we gave you a warning, you were late, and you're late again. We're letting you go, and by the way, we're letting you go for cause, which really means you're not getting any compensation, any severance. So she called me, she watched our show, and she wanted to know, can my employer do this? So let's start, Dana, by me saying that, yes, she certainly did something wrong. Mm-hmm. You should be at work on time. I'm not trying to suggest otherwise. I'm not condoning that. She made a mistake. She did something wrong. She was not at work when she needed to be. But that's not the question. The question is whether the punishment fit the crime. Okay? Mm-hmm. And the reality is it's not even close. The only time you can be let go for cause, which means you don't get any compensation, is if you've done something so bad that it really is impossible to continue employing you. Look at it like the death penalty of the employment relationship. It's reserved for the worst offenders. So you may have done something wrong. Maybe you've even done a few things wrong. Not a good thing, but not cause. Does not allow the company to let you go without compensation. If they want to let you go, sure, they can let you go, but they'll have to pay you your full severance. So I want to make that distinction between doing something wrong and being let go for cause. There's a big, big difference. Now, if the company gave her more warnings, they gave her additional opportunities, and she kept being late, sure, at some point that employer could put up their hand and say, what more can we do with this employee? We've tried everything. The only option we have is to let her go for cause. That's not what they did. She deserved more opportunities to improve. And I see this often, employers pulling the trigger on a termination for cause well before they should. It's a very common thing, so you have to keep that in mind.
Okay, if you want to get in touch with Lior and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. Let's kick things off by taking our first call, Lior. These calls come from your radio show across Ontario and Canada, where you take questions live from listeners about their employment law issues. Take a listen.
I've been working for a company approximately 20 years in the office doing secretarial work. They've now given me a letter that they're going to take me off salary and put me on an hourly rate. And then there was a clause of termination without cause and no severance pay. I would not sign this. I wanted your opinion.
Can they do that?
Well, no, they can't.
Okay.
And it's, by the way, something that I see often, an employer changing the compensation structure. So they may not necessarily be reducing your pay, but they're changing the structure. So you go from hourly to salary or vice versa. Or maybe your commission is changed and you're going to be, instead of just 100% commission, you're going to get commission and salary, or again, vice versa. Anytime your compensation is impacted, even if the dollar amounts may stay the same, but the structure changes, it's not something an employer is allowed to do. It's a very common form of constructive dismissal. So going from hourly to salary or the other way around is not something you have to accept. So if that's the change that your employer is implementing, your first option, yeah, you can accept it and continue working, obviously. But the other option is you can treat that as a termination of your employment and require your employer to pay you severance. The question, of course, then becomes, well, how much severance am I owed? So let's take that fact scenario that we just looked at, and let's plug it into pocketemploymentlawyer.ca. We have our severance calculator tool there that's free and anonymous and anyone can use. And let's see, in fact, what pocketemploymentlawyer.ca tells us. We see that this person has been there for many years now, some 20 plus years, 56 years of age. She wasn't provided any severance because the employer believes that they can impact her employment that way. And we see that she's owed as much as 18 months' pay. 18 months. That's a significant amount of severance. And remember, this person has not been let go. Okay? This person may treat their employment as a constructive dismissal. Same with our viewers at home. If your compensation structure or any significant term of employment is being changed, you have that option potentially to look at it as a constructive dismissal.
Okay, let's take a short break. And when we come back, employment lawyer Lior Samfiru from employmentlawyer.ca will explain what wrongful dismissal really means and why it's important. Stay with us. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. Welcome back to Ask a Lawyer. Employment lawyer Lior Samfiru from employmentlawyer.ca is answering questions about your workplace rights. If you want to get in touch with Lior and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. We have more calls and emails coming up. Lior, before jumping to those, let's get to today's main topic, wrongful dismissals and what you need to know. Does a wrongful dismissal mean you've been fired for the wrong reason?
So I can tell you that as an employment lawyer, probably 80% of what I do and my colleagues do is we deal with wrongful dismissal situations. There's a lot of misconceptions when it comes to wrongful dismissal. Just that term, wrongful dismissal, would suggest to someone that I was let go for a wrong reason. And it's easy to believe that. But that is not what a wrongful dismissal is at all. Keep in mind, we've said this in the past, that generally speaking, an employer can let you go at any time and kind of pretty much for any reason, as long as they pay you proper severance. So you may disagree with the reason you were let go, and you think that the employers may be being dishonest about the reason. But from a legal standpoint, they can do that. It may not be nice, but they can do that as long as they pay proper severance. So what is a wrongful dismissal? A wrongful dismissal is simply a situation where you have been let go without getting the severance that you are owed. Now, what I want you to know, and I want our viewers to know, that about 90% of people, when they are let go, actually are wrongfully dismissed. It is the most common thing. Most of the time when you're let go, you're staring at that severance offer. It's not adequate. And that, Dana, is what a wrongful dismissal is.
Okay, so can a significant change to your job result in a wrongful dismissal?
So if we're talking about a wrongful dismissal being a situation where you have not received proper severance, well, if you're let go and don't get any severance, that obviously is a wrongful dismissal. And that's what happens if your employer makes a significant change to terms of employment. The law considers that to be a termination, a constructive dismissal. So if you haven't received severance and that's what's happened to you, then you've been wrongfully dismissed. So bottom line is that a constructive dismissal is a type of wrongful dismissal, meaning you are owed severance in that situation.
So how is severance pay calculated? Is it just 1 week per year of service?
You know, if we ask 10 people on the street, how is severance calculated? They tell us it's a week per year or maybe 2 weeks per year. None of that is correct, not at all.
None.
Severance is not that linear, it's not that straightforward, and it's based on a number of factors. The main factors are your age, your position, and the length of your employment. Longer you work, the older you are, and the more senior a position, the greater your severance entitlements, and you could be owed as much as 24 months' pay. It's usually a lot more than a week per year or 2 weeks per year. You could be owed several months severance, even if you've worked for a few months. And as I mentioned before, I think it's worth mentioning again, if you want to find out now how much severance you're owed, you don't have to wait, you don't have to wonder, just go to pocketemploymentlawyer.ca, use our severance calculator tool, completely free and anonymous, and you'll find out what the real amount is.
How long do you have to pursue a claim for wrongful dismissal?
And that is important. You have 2 years from the date that you have been let go. That is a strict timeline. It's statute barred. You can't pursue it for more. If it's 2 years and an hour, unfortunately, you're out of time. And Dana, every week I talk to people that have heard me on this show, they've heard me on radio, they want my help, but it's been more than 2 years since they've been let go. Can't help you. So certainly time is not on your side if you lose your job. You want to deal with it as soon as possible.
How can an employment lawyer help with a wrongful dismissal claim?
Well, we talked about a wrongful dismissal and what it is. What a lot of people don't understand, it's actually not difficult to resolve these wrongful dismissal claims. When people think about going to an employment lawyer or a lawyer generally, you think of long legal proceedings, going to court, huge costs, and why would anyone want to put themselves through that? And I get that. But when it comes to wrongful dismissal and employment law generally, the law is so straightforward that it's not difficult to resolve these issues. Oftentimes it can resolve within a couple of weeks. Oftentimes all it takes is for me to send a letter to the employer saying, you've offered this much severance, here's how much this person is owed, so pay what they owe, and that gets resolved. So I want to make sure that individuals are not afraid about the legal process. Certainly not when it comes to wrongful dismissal. They should not hesitate to pick up the phone and call if they lose their job.
Okay, let's get to more of your questions. Here's another caller from your radio show. Take a listen.
I was diagnosed with cancer a while ago, and I applied for long-term disability through work so I can take time off to fight it. Last month, the insurance company cut me off, and a few days later, I was fired with no severance pay. I'm not really sure what I should do.
So that's a double whammy. So you're cut off by your insurance company even though you're still sick, and at the same time, your employer says, if you don't come back to work, we're letting you go. All the while you're sick, you cannot work. Well, the good news is both those issues can be resolved. We can deal with your insurance company to make sure that they don't cut you off because they should be following what your doctor says. If your doctor says this person is not ready to work, your insurance company should not cut you off. I know they want you to be off. I want you to be off their payroll, but that's not appropriate. And certainly with respect to the employer, if your doctor says you cannot work, again, the employer can't fire you for being sick. That's a human rights violation. So that much more important. If you're sick, if you're unable to work, if you're not getting your benefits, if your employer is threatening your job, you must make that call and get some advice.
Okay, that's great advice. Let's take a short break, and when we come back, Lior from employmentlawyer.ca will review a $17,000 severance package and explain how a bonus is factored into your compensation. Stay with us. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. And welcome back to Ask a Lawyer. Lior Samfiru from employmentlawyer.ca is taking questions about your workplace rights. If you want to get in touch with Lior and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. We still have lots more to discuss. Here's another question that recently came in. Take a listen.
My mom worked at a company for 27 years. 9-hour shifts, 5 days a week. She won't disclose what she signed, but she signed the paper. This is about 4 years ago now. And I said, oh, dear God, you were 70 when you retired. You only got $17,000 after 27 years. So what do you think about that?
Wow.
What do you think?
Well, first of all, this is a very common question when I can't actually help someone because too much time has passed. So as I said in the previous segment, if you lose your job, you want to deal with it right away. Time will pass and then your rights will expire along with it. But it's still important for us to understand what this person would have been owed had she dealt with the matter in a timely fashion, because you may be in the same situation. So rather than me tell this person how much she's actually owed, let's, as always, go to pocketemploymentlawyer.ca. We'll use our severance calculator tool that you can use at home as well, and let's see how much compensation, how much severance this person is actually owed as opposed to what she received. So this person was 7 years of age, worked there for 27 years, a long time, and we see that she was offered $17,000. What was she owed? Well, she was actually owed 24 months' pay. Now, depending on her salary, that could be a delta of probably over $50,000 right there. So that $17,000 offered and paid at that time was completely inadequate. 2 years' pay is what this person was owed. That's why it's so important. That's why we created this tool, so that you have this information that before you'd have to call a lawyer and make an appointment to get, you can get it in the privacy of your own home on your smartphone and tablet. So your best friend if you lose your job is pocketemploymentlawyer.ca.
Okay, we have an email from Ali that was sent to ask@employmentlawyer.ca. I was given a severance package this week. It only seems to reflect my base salary and doesn't consider the bonus I have consistently earned every year that makes up 40% of my earnings. What should I do?
So Dana, we've been focusing on the number of months that an employee is owed when they lose their job, and obviously that's important. But there's another aspect to severance, and that is what is included in that. So it's not just your salary when it comes to your severance. Your severance must reflect all components of your compensation. So that's salary, benefits, bonus, pension, car allowance, stock options, you name it, whatever you have as part of your compensation must be included in terms of your severance. Now, your employer is not going to forget about your salary when it comes to your severance. But what about those other components? Very common for those to not be included and us have to get involved to get those. And sometimes those could be worth more than the salary. If you want to know if something should be included in your severance, you ask yourself a very simple question. Would I have received it had I continued working? If the answer is yes, I would have, then it has to be part of your severance as well. So very important to remember that, yes, the number of months you're owed is very important. What's included is equally important. That's why you cannot ever sign that severance offer before you know for a fact that you've received everything that the law says you're owed.
Good advice. Let's take one last break. When we return, Lior from employmentlawyer.ca will talk about probation periods and when you shouldn't call the Ministry of Labor. Stay with us. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. Welcome back to Ask a Lawyer. Lior Samfiru from employmentlawyer.ca is answering your employment law questions. You can connect with his team by calling 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. We have time for a few more emails. Here's one from Tara. My boss put me back on a 6-month probation period after I made a small mistake. The last time I was on one was when I started the job 2 years ago. Are they allowed to make it that long? Lior.
So here's the answer, and you may be surprised. So it's not that they're not allowed to do this, it's that it's meaningless to do that. Because a probationary period can really only last 3 months. The first 3 months of employment is if the goal of that probationary period is to let someone go without compensation. You're only allowed to do that for 3 months. So the fact that you're calling someone as being on probation for 6 months or 12 months doesn't mean anything. The law does not distinguish between that person and a regular employee. So if it makes the employer feel much better to say you're on probation, fine. It's not illegal per se, but if she were to lose her job in that situation, yes, she's going to be owed severance, despite the fact that her employer says probation. So for all intents and purposes, Dana, really a probation is something that can only last 3 months, the first 3 months of employment. And again, it's not automatic. You're only on probation if you sign an employment agreement that says that first 3 months you're on probation. Otherwise, probation does not exist automatically.
Really? Oh, good to know. Okay, here's another email sent in from David to askanemploymentlawyer.ca. A friend told me that no matter what my employment is about, I should always take legal action through the Ministry of Labor. Is that true?
It's a very important question. Now, if you have an overtime issue, a vacation pay issue, a holiday pay issue, yeah, you can and you should, in fact, go to the Ministry of Labor. They can help you. But when it comes to losing your job, the severance, the amount of compensation that you're owed when you lose your job, you cannot and should not ever go to the Ministry of Labor. First of all, the Ministry of Labor can only help you enforce your minimum entitlements, not your full entitlements. So that's only a small portion of what you're owed. That's bad enough, but unfortunately, it gets much worse than that. By going and filing a claim with the Ministry of Labor for your severance, you're actually then prevented from pursuing your full entitlements. So you could be losing tens of thousands, maybe even hundreds of thousands, by filing a complaint with the Ministry of Labor if you lose your job. The worst thing that you can do, you're better off going on Google and getting your information there than going to the Ministry of Labor. I'll give you an example. Let's say you work for an employer for 4 years. You call the Ministry of Labor, you say to them, what am I owed? They'll tell you 4 weeks' pay. In fact, you're probably owed 6, 7, or 8 months' pay. Now, and if you're filing a complaint with the Ministry of Labor, you'll get your 4 weeks, but you will be prevented from pursuing your full entitlements. So no matter what, if you lost your job, cannot go to the Ministry of Labor. For that, you have to get legal advice.
Lior, thank you. And thank you so much for being here today. You can catch legal experts from employmentlawyer.ca on Ask a Lawyer every Wednesday on CP24. For more information on this show and employmentlawyer.ca, visit cp24.com/askalawyer. Join us again next week as we discuss the key facts about employment contracts that you don't want to miss. Thanks for watching.